Ready, start. The inquiry by the court is neither attributable to the investigation nor the prosecution, but by the court itself for collecting information to draw back a curtain that hides something material. It is the duty of the court to do so, and therefore the power to perform this duty is provided under CRPC. It is therefore not any material that can be utilized, rather, it is that material after cognizance is taken by a court that is available to it while making an inquiry into or trying an offense that the court can utilize or take into consideration for supporting reasons to summon any person on the basis of evidence adduced before the court who may be on the basis of such material treated to be an accomplice in the commission of the offense. The inference that can be drawn is that material which is not exactly evidence recorded before the court but is a material collected by the court can be utilized to corroborate evidence already recorded for the purpose of summoning any other person other than the accused. They should harmonize such material with the word double inverted comma evidence double inverted comma close as material that would be supportive in nature to facilitate the exposition of any other accomplice whose complicity in the offense may have either been suppressed or escaped the notice of the court. The word double inverted comma evidence double inverted comma close therefore has to be understood in its wider sense both at the stage of trial and comma as discussed earlier comma even at the stage of inquiry comma as used under section 319 CRPC. The court therefore should be understood to have the power to proceed against any person after summoning him on the basis of any such material as brought forth before it. The duty and obligation of the court becomes more onerous to invoke such powers cautiously on such material after evidence has been led during trial. We have given our thoughtful consideration to the diverse views expressed in the aforementioned cases. Once examination in chief is conducted, the statement becomes part of the record. It is evidence as per law and in the true sense, for at best it may be rebuttable. An evidence being rebutted or controverted becomes a matter of consideration, relevance, and belief, which is the stage of judgment by the court. Yet it is evidence and it is material on the basis whereof the court can come to a prima facie opinion as to complicity of some other person who may be connected with the offense. Therefore, no straitjacket formula can and should be laid with respect to conditions precedent for arriving at such an opinion, and if the magistrate/court is convinced, even on the basis of evidence appearing in examination in chief, it can exercise power under section 319 CRPC and can proceed against such other person. Hence, what is required to be observed is not to have a mini trial at this stage by having examination and cross examination and thereafter rendering a decision on the overt act of such person sought to be added.